You have the right to remain silent. Anything you say can and will be used against you in a court of law. You've heard this a million times in movies and TV shows, but 80% of Americans don't actually understand what these rights mean or when police are required to read them to you. And that misunderstanding can cost you your freedom. With USA Rights Simplified, where we break down your constitutional rights in plain English. Today, we're explaining Miranda rights, what they actually mean, when cops must read them, and the massive loophole most people don't know about. This could be the most important 8 minutes you watch this year. We'll cover the history of how these rights came to exist, what each sentence actually protects you from, when police are legally required to read them to you, and the critical situations where they don't have to, which is where most people get tricked. Let's get started. First, let's get the basics clear. Miranda rights, officially called the Miranda warning, are a set of constitutional protections that police must inform you of before conducting a custodial interrogation. That's the legal term, and we'll break it down in a second. The warning comes from 2 amendments in the Bill of Rights. The Fifth Amendment, which protects you from self-incrimination, meaning you can't be forced to be a witness against yourself, and the Sixth Amendment, which guarantees your right to an attorney. Together, they create what we now call Miranda rights. Here's what police are supposed to tell you word for word. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand these rights as I have read them to you? That's it. Those 4 sentences are supposed to protect you from being coerced into confessing to crimes. But here's why this matters so much. Before Miranda rights existed, police could interrogate people for hours, sometimes days, without telling them they could refuse to talk or get a lawyer. People would confess to crimes they didn't commit just to make the interrogation stop. Miranda rights changed that. They put a legal barrier between you and aggressive interrogation tactics. So where did these rights come from? The answer is a 1966 Supreme Court case called Miranda versus Arizona, and the story is pretty wild. In 1963, a man named Ernesto Miranda was arrested in Phoenix, Arizona for kidnapping and sexual assault. Police interrogated him for 2 hours without telling him he could remain silent or have a lawyer present. During that interrogation, Miranda confessed. At trial, that confession was the key evidence used to convict him. He was sentenced to 20 to 30 years in prison. But Miranda's lawyer argued that the confession shouldn't have been allowed in court. Why? Because Miranda wasn't told he had the right to stay silent or the right to legal counsel. He didn't know he could refuse to answer questions. The case went all the way to the Supreme Court. And in 1966, in a 5-4 decision, the court ruled in Miranda's favor. They said that confessions obtained during police interrogations are only valid if the suspect was first informed of their constitutional rights. This ruling created what we now call Miranda rights. From that day forward, police across America have been required to read suspects these warnings before custodial interrogation. Interesting side note, Ernesto Miranda was actually retried without the confession as evidence, and he was still convicted based on other evidence. He was released on parole in 1972. Tragically, he was stabbed to death in 1976 during a bar fight. The suspect in his death was read his Miranda rights and chose to remain silent. He was never charged. Today, Miranda is one of the most famous Supreme Court cases in American history. The warnings are so ingrained in our culture that everyone recognizes them from TV and movies. But as you're about to see, most people completely misunderstand how they actually work. Here's the critical part most people get wrong. Police don't have to read you Miranda rights every time they talk to you or even every time they arrest you. They only have to read them when 2 conditions are met at the same time. 1, you're in custody, meaning you're not free to leave. And 2, you're being interrogated, meaning police are asking you questions designed to get incriminating answers. Both conditions must exist. Custody plus interrogation equals Miranda required. So what counts as custody? Custody means a reasonable person wouldn't feel free to leave. This includes being arrested and handcuffed, being told you're not free to go, being put in the back of a police car, being held in a police station interrogation room. But here's what custody does not include. Regular traffic stops, you're detained but not in custody for Miranda purposes, voluntary police interviews where you can leave anytime, police asking you questions at your front door, being questioned at a crime scene if you're not a suspect. This is huge. Most police encounters don't qualify as custody. Now, what's interrogation? Interrogation means police are asking you questions or making statements designed to get you to incriminate yourself. This includes direct questions, did you rob that store? Indirect questions, where were you last night? Statements designed to prompt a response. Your partner already told us everything. Don't you want to tell your side? But interrogation does not include routine booking questions like name and address, questions for public safety like where's the gun, casual conversation you initiate, spontaneous statements you make without being asked. This is the loophole police use all the time. So putting it together, if you're arrested but police don't question you, no Miranda required. If police question you but you're free to leave, no Miranda required. Miranda only applies when you're in custody and being questioned. That's why police might arrest you, put you in the car, and not say a word until they get to the station. They're avoiding triggering Miranda until they're ready to interrogate you formally. Now here's the loophole that gets thousands of people convicted every year. Spontaneous statements. If you're in custody and you just start talking without being asked questions, police do not have to read you Miranda rights, and everything you say can still be used against you in court. Let me give you an example. Say you're arrested for a robbery. Police put you in handcuffs, put you in the back of the police car, and drive to the station. They don't ask you a single question. But you're nervous, so you start talking. Man, I can't believe you guys think I did this. I wasn't even in that neighborhood. My friend dropped me off at 9 p.m. I didn't steal anything. Guess what? You just gave them your alibi, placed yourself in a specific location at a specific time, and mentioned a friend they can now interrogate, all without Miranda being read and all admissible in court. There's another huge exception called the public safety exception. If police believe there's an immediate threat to public safety, they can ask you questions without reading Miranda first. The classic example, police arrest someone for shooting up a school. They can ask, where's the gun? Or are there explosives? Without Miranda because there's a public safety concern. But some police departments stretch this exception way beyond its original intent. And here's the scariest part. You can waive Miranda rights either explicitly or implicitly. Explicitly means you say, yes, I understand my rights and I'm willing to talk anyway. Implicitly means you just start answering questions after hearing the warning. Courts have ruled that if you understand the rights but choose to talk anyway, you've waived them. This is how most confessions happen. Police read the rights, the suspect thinks, I have nothing to hide, or I can talk my way out of this, and they start answering questions. Boom, waived. So what happens if police don't read you Miranda rights when they should have? The answer is called the exclusionary rule. Any statements you made during that unwarned custodial interrogation cannot be used as evidence against you in court. They get excluded, thrown out. This is a huge deal. If your confession is the main evidence against you and it gets excluded, the entire case might fall apart. But here's the catch. The violation doesn't automatically dismiss charges. Your lawyer has to file a motion to suppress the statements. The judge then holds a hearing to decide if Miranda was required and if it was violated. If the judge agrees with your lawyer, the statements are suppressed and can't be used at trial. If the prosecution has other evidence, they can still try to convict you, but without your own words being used against you. Here's a real example. In 2010, the Supreme Court decided a case called Berghuis versus Thompkins. A suspect was read his Miranda rights and then stayed mostly silent for nearly 3 hours during interrogation. Then finally, he answered one question. "Do you pray to God for forgiveness for shooting that boy?" He said yes. The court ruled that because he didn't explicitly invoke his right to silence, he just stayed quiet, his eventual statement was voluntary. The confession was allowed in court, and he was convicted. The lesson: simply staying quiet is not enough. You must explicitly invoke. I am invoking my Fifth Amendment right to silence, and I want a lawyer. Say those exact words. Okay, so now you know what Miranda rights are and when they apply.
Here's exactly how to use them to protect yourself. Step 1. If you're arrested or detained, assume you're in custody. Immediately invoke your rights before any questioning starts. Say, I am invoking my Fifth Amendment right to remain silent and I want a lawyer. Step 2. After invoking, stay silent. Don't explain yourself. Don't try to seem cooperative. Don't make small talk. Silence means silence. Step 3. Wait for your lawyer. Don't sign anything. Don't agree to anything. Don't answer even casual questions like, are you hungry or do you want water? They might be trying to get you talking. Step 4. When your lawyer arrives, talk only to your lawyer. Not to police, not to other inmates if you're in jail, not to anyone else. Your lawyer will advise you whether to answer any questions. Mistake 1. Thinking they can talk their way out of arrest. You can't. If police have decided to arrest you, talking won't change that. Mistake 2. Thinking that refusing to talk makes them look guilty. It doesn't. Invoking your rights is constitutionally protected and can't be used against you. Mistake 3. Answering just this one question after invoking. Once you start answering, courts may decide you've waived your rights again. Let's recap. Miranda rights protect your Fifth and Sixth Amendment rights. Police must read them before custodial interrogation, custody plus questioning. But spontaneous statements, traffic stops, and public safety exceptions are huge loopholes. If you're ever arrested, immediately invoke, I am invoking my Fifth Amendment right to remain silent and I want a lawyer. Then stay silent. Don't waive your rights by talking. Your action item. Screenshot this sentence and save it in your phone right now. I am invoking my Fifth Amendment right to remain silent and I want a lawyer. If you're ever arrested, that's all you say, nothing more. If this helped you understand Miranda rights, hit that like button and subscribe. We post new legal rights videos every Tuesday and Thursday. Comment below. Did you know about the spontaneous statements loophole? I read every comment. Important disclaimer, this is educational content, not legal advice. Miranda law has exceptions and complexities that vary by jurisdiction. If you're facing criminal charges, hire a criminal defense attorney immediately. Your freedom is too important to risk. Thanks for watching USA Rights Simplified. Knowing your rights is the first step to protecting them. See you in the next video. Stay informed, stay protected.